Thank you. I'd very happy to call to order the Standing Committee on Public Safety and National Security for this, our 28th meeting, as we consider the national security framework as a study. And we very much want to thank the Minister, Mr. Goodale, for joining us today, as always. And we also welcome the Deputy Minister, who is relatively new to the position, and I believe your first time at our committee. And you'll find we're an excellent committee, as you will tell by our questioning and our knowledge of the subject. We welcome the Minister to give opening remarks, and we have him here for the first hour of our meeting. Officials will gather following, and you're on. Thank you.
Well, thank you, Mr. Chairman, and good afternoon, members of the committee. It's a pleasure to be back again. Thank you for the invitation to come on this occasion to talk about the consultations on the national security framework. And I want to begin by thanking this committee for undertaking that study. It's an integral part of the government's approach to the future with respect to national security, and I'm grateful to have the committee's participation in the examination of that framework. I too want to welcome Malcolm Brown. The first time he's had the opportunity to appear before the committee as Deputy Minister of Public Safety, and I rely upon his good work and that of the women and men who toil in the department so faithfully to support the safety interests of Canadians. In the second hour, you will have the Director of CSIS, Michelle Colombe, and the Commissioner of the RCMP, Bob Paulson, in front of you. Those are always exceedingly interesting sessions. But even though he's not here at the moment at the table, I would like to acknowledge particularly Commissioner Paulson, who this morning made an historic announcement about a court settlement and an apology and an approach going forward that will turn the page, we all hope, on a period of some considerable distress within the force having to do with harassment and sexual violence in the workplace. That announcement was exceedingly important this morning, and I congratulate all of those involved, including the Commissioner, but also the very brave women who led that process over the course of the last number of years and had the patience and the persistence and the courage and the perseverance to see it through to a successful conclusion. Mr. Chairman, I want to thank this committee for its work consulting with parliamentarians and with Canadians generally about Canada's national security framework. This helps to fulfill a commitment that we made to Canadians last year to give them an opportunity to have input on national security issues and to be as inclusive and transparent in that process as possible. Before I wade into more details, let me pause for one more short detour, and that is to thank the committee for the report you filed earlier this week about post-traumatic stress injuries, which of course disproportionately affect first responders. Dealing with that challenge is another of my priorities on behalf of firefighters, police officers, and paramedics who work every day to keep the rest of us safe and secure. The committee's report was very well done, and it will be very helpful to the government as we bring forward a coherent national strategy for PTSI among our vital emergency response personnel across the country. Now, with respect to public consultations on Canada's national security framework, this initiative to have public consultations is absolutely unprecedented. We want to hear from parliamentarians, subject matter experts, and Canadians generally about how we can best achieve two overarching objectives. We need to ensure that our security and intelligence agencies are effective at keeping Canadians safe, and simultaneously, we need to be equally effective at safeguarding our rights and freedoms and the open, inclusive, fair, and democratic character of our country. I began this consultation work on this topic many months ago. We've collected important input from respected academics such as Professors Wark and Forsays and Roach, from security and intelligence operators like Ray Boisvert, who was formerly with CSIS, and Luc Portelance, who was formerly at the CBSA and before that the RCMP. I've also heard from former MPs like Bob Rae and Anne McClellan and Irwin Cotler, as well as Hugh Segal from the Senate and Senator Romeo Dallaire. I've met with a number of other current MPs and senators, and with outside groups like the BC Civil Liberties Association, Open Media, and various organizations representing Muslim lawyers and other professionals, and many more. That's a good start, but my direct meetings are going to be ongoing because the consultation is ongoing, now augmented by the active and very welcome outreach by this committee. And more broadly, we have launched, as of last month, an open public consultation online, and it will be running until the 1st of December. By way of background, in the summer, the government published its 2016 public report on terrorist threats to Canada. That report covered the period through 2015 and into the beginning of 2016, highlighting the particular threat posed by individuals or small groups of lone wolves who get inspired to violence in some perverted way by the insidious influences of organizations like Al-Qaeda and Daesh. The report, that is the threat report, also included, for the first time, a description of Canada's national terrorism threat level. That level, by the way, is currently set at medium, where it remains unchanged since October of 2014. To begin our online conversation with Canadians last month, the Minister of Justice and I posted a discussion paper and a backgrounder on our website. These do not purport to be statements of government policy. They are intended to elicit ideas and to provoke engagement on national security, and they certainly seem to be achieving that effect. Thus far, more than 8,000 responses have been received, with nearly 2 months yet to go in the consultation process. And as I said, this online consultation will run until the 1st of December. And whether it's our discussion with subject matter experts or your committee work talking to experts as well as other parliamentarians and Canadians generally, or the input that we are getting online, we're looking for 2 types of advice. How can we enhance the effectiveness of our security agencies, and how can we equally and simultaneously safeguard our rights and freedoms, our open, inclusive, democratic society, and our Canadian way of life? These 2 core themes underpin our entire national security agenda. And on that point, I have noticed, of course, the report last week and the committee appearance this week of the Privacy Commissioner about the sharing of information. I consider Mr. Therrien to be a key part of parliamentary oversight and accountability apparatus. I take his input very seriously, and I've already had one discussion with him about the points that he raised in his report, and others will follow. In the meantime, in response to his point about privacy impact assessments in various government departments, I am now writing to all of my cabinet colleagues to ensure that all departments and agencies have in place the right privacy-related protections to deal with the issue of information sharing. To close this introduction, Mr. Chairman, let me put these national security consultations in the context of our overall national security agenda as a government. That agenda includes the following points. First of all, the creation of that new committee of parliamentarians that is reflected in Bill C-22 that you will have before you for consideration at another time. But that is a cornerstone piece to bring a brand new element into our oversight, scrutiny, and review architecture that has never before existed in Canada, but which has been recommended on a variety of occasions by parliamentary committees, by the Auditor General, by external independent inquiries, and so forth. Bill C-22 will remedy the defect of that deficiency. Secondly, we are hard at work at a new Office of Community Outreach and Counter-Radicalization. The money for that was provided in the budget, and we're in the process now of identifying the individuals who will be best placed to deliver that new initiative. Thirdly, we will ensure faithful compliance with the Canadian Charter of Rights and Freedoms. Fourthly, clarity with respect to warrants. Fifth, a more precise definition of propaganda. Number 6, repairs to no-fly lists, and in particular, the appeal process that relates to no-fly lists. Number 7, full protection of the right to protest. Number 8, a statutory review after 3 years of our anti-terrorism legislation. Number 9, a new arrangement with the United States with respect to our common border, including a much improved pre-clearance system and the establishment of an entry-exit data collection mechanism for the first time, as well as other improvements in the arrangements with respect to no-fly lists. And number 10, and for the first time, this process. Canadians are actually being thoroughly consulted about what other steps, in addition to what I've already mentioned on the agenda, what other steps do Canadians believe are necessary to keep them safe and to safeguard our rights and freedoms? Thank you, Mr. Chairman.
Thank you very much, Minister. Thorough and helpful. We're going to begin our 7-minute round questioning with Mr. Spangeman.
Thank you, Mr. Chair. Thank you, Minister Goodale, Deputy Minister Brown. Thank you both for being here. I wonder if I can take the opportunity of going first in my questioning to ask a couple of stage-setting questions. Another committee I serve on is the Standing Committee on National Defense, and that committee, in the context of a review of North American aerial readiness, received testimony that the single biggest threat to Canada is domestic terrorism. And I'm wondering, drawing on the 2016 reports that I've read with interest on the terrorist threat to Canada, if you could tell the committee whether or to what extent you agree with that, if that's too simple a conclusion from your perspective, if the threat is more multifaceted than that.
The threat is certainly multifaceted, and it comes in many ways. But identifying the threat of terrorism, and in particular the inspired lone wolf, I think, is identifying one of the key areas upon which we need to concentrate our efforts. The threat report that was published in the summer indicated a number of things that seem to be new or evolving in the structure of threats that are affecting Canada. One of those is the advent of new technology that is always changing all the time. Another is actually the gender makeup of some of the threats that we deal with, and an increasing presence of women in the matrix. But still, at the moment, and Director Colomb would be able to give you a good deal of texture with respect to this analysis. One of our key concerns are those lone wolves that are on the internet or somehow get inspired by Al-Qaeda or Daesh and get on a path to violent behavior. That's why we have a particular focus on the counter-radicalization initiative to try to put ourselves in a position to identify that risk in advance and, to the extent you can, head it off.
Thank you for that. I'm wondering, just to add briefly to that, if you could tell the committee generally, because I'm assuming there's classification levels involved here, the extent to which the threat level varies with the intensity of commitments of our armed forces abroad in other missions, and whether it's military missions, peacekeeping missions, other exercises in the Middle East and Central Asia. In other words, to put it in very simple terms, does the threat increase the more we do abroad?
Well, obviously, I need to be careful in answering that question because, as you say, classified information is involved. But one of our leading priorities is to make sure that when Canadians are in harm's way, that they are properly protected to the maximum extent possible.
Okay, that's helpful. Thank you, Mr. The second line of questioning draws on a byline in the 2016 report on the terrorist threat to Canada, and it talks about building a safe and resilient Canada. And my colleagues will take you into the details of the mechanisms that you're proposing in the National Security Framework. But I'm wondering if you could talk a little bit about the role of Canadian society with respect to good security and good safety. What I'm particularly interested in is how Canadians perceive security in 2016, national security, and what their role is. I mean, the fact that you itemized consultations as a very important part of our commitment will bring Canadian society into the discussion. What is the role of Canadian society in making us resilient, not only in the prevention of attacks, but also socially resilient? And if that's the right path to go down, how important are relationships, not just between communities and government, but between communities with respect to counter-radicalization and tackling the misperceptions and distortions that are embedded in the term terrorism?
Oh, that's not only important in terms of our national security, it's an instinctive part of the character of Canadians, I think, to want to build that sense of cohesion. We're a country that is extraordinarily diverse. I think it was the Aga Khan who said that Canada is the finest example of pluralism the world has ever seen. And that's a great compliment, and obviously he is an honorary citizen of this country, and we take that compliment very sincerely and gratefully. But in that diversity, you constantly have to work at social cohesion. And that involves reaching out to each other and understanding one another, trying very hard to build bridges with each other. And in the kind of country we have and the kind of history we have, we're held together not so much by the force of law or the force of arms, but by our common will. We're a successful country because we want to, not because we have to. And you have to keep promoting that sense of common cause and understanding and outreach. This consultation is intended for two purposes. To let Canadians have their say, and they've wanted to have their say for a long time, and this is the first time in history that they're going to get it, so they're participating in the process, but also by listening to the conversation, whether it's at this committee table or online or in the other rooms in which the consultation is taking place, hopefully will elevate the level of understanding about what national security means, what the framework is, what the threat level is, and reinforce the point, too, that fundamentally we are a safe and peaceful country. And we need to make sure we keep it that way. But Canada is in a very privileged position in the world.
Thank you, Mr. Chair. Yeah. I'll leave it there. I'll delegate the rest of the time to the next level speaker.
Mr. Miller.
Minister, thanks again for being here. It's always great to have a minister at the committee. I want to talk about the new powers that were granted under C-51 to CSIS, and basically it gave them the new powers to disrupt potential threats, and there's different things, whether it's telephone calls, travel plans, etc. But before the changes in C-51, CSIS could only inform police agencies of potential threats and could not act on them alone. But through the last election, Mr. Minister, your party basically came out and said they were going to make major changes to it. Now, the director of CSIS appeared before a Senate committee on March earlier this year, and he indicated that the agency had used their new powers close to 24 times since C-51 came into source, and of course 6 more months have passed since then. And he also indicated that it is likely they'd use these powers again in the future. Now, also during an interview following being at the Senate committee, Director CSIS stated that the national security review that the government is currently engaged in, that a decision would likely be made that could affect the power and others. So, you know, seeing, Mr. Minister, that Corporal Cirillo, if the powers that be would have had the proper things at the time, probably would still be alive. And we were all here 2 years ago when that happened, and I'm sure you were as well. And also, the would-be terrorist driver, his last name I believe in Strathroy a few months ago, probably wouldn't have been caught without these new changes. So my question is, do you intend to change them? And if so, how do you see these powers changing, as clearly they've been effective in disrupting potential threats thus far?
Well, Mr. Miller, thank you for your greeting. On the threat reduction activities, that is one area where we want to listen very carefully to Canadians' views, because views are mixed on that power. If you remember, the original creation of CSIS flowed out of a decision by a previous government to remove intelligence functions to a significant extent from the RCMP and hand them over to an independent agency that would specialize in intelligence, while the RCMP would deal with policing issues. And there was a policy decision at that time to separate the two functions. Now, many years later, the legislation was changed that tends to in some ways merge them back together again. And I think we need to think carefully about that.
But do you intend to change them, Mr. Minister?
The commitment that we made in the platform was to ensure compliance with the Canadian Charter of Rights and Freedoms.
Of course.
That was the commitment that was made. And there was language in C-51 that tended to contradict that. So that is the issue that needs to be addressed. Compliance with the Charter.
Okay, I'm running out of time. You really haven't said, are you going to change them or not? And how would that look at if you do? And, I mean, that's the answer to one is very quick, yes or no. And the other one, if it's yes, then how? And
well,
so
the point, Mr. Miller, why would you have a consultation if you've already determined the answer to the question? As I said at the beginning of my answer, we want to hear Canadians on this subject. The bottom line for us is compliance with the Canadian Charter of Rights and Freedoms. Okay,
did you consult then prior to making that announcement during the election? I think that we know...
what announcement?
We know that, well,
we announced compliance with the Charter. That's what we announced.
Yeah, well, it goes beyond that, I think. Now,
well, that may be your platform. It's not mine.
No, well, it was your party said it.
No, we didn't.
So,
read
anyway,
the platform, page 55. I'm happy to send you a copy.
Yeah. I'm going to move on here. We all know, and in fact you even said that organizations that have used the new powers, Citizenship and Immigration Canada, the CBSA, CSIS, and a fourth unnamed agency have used these. So it's obvious, Mr. Minister, that the changes have been used, and I'm sure they wouldn't be used unless they were a valuable tool.
Well, you've segued from one power to another. You've segued from threat reduction activities, which is the subject of your first question, to information sharing, which is the subject of your second question. And the two are quite different subjects.
Okay, that's fine, but I wasn't getting much of a response to the other, so I moved on. So on that, are you going to change the information sharing process? Because obviously these organizations are saying that they're using it, and it seems to be working.
In respect of that new piece of legislation, which was introduced as a part of C-51, what we've indicated just in my remarks today is that the Privacy Commissioner has indicated, in his view, that there are some defects in the process, including whether or not privacy impact statements have been properly prepared and so forth. And what I've undertaken today, further to my conversation with the Privacy Commissioner a few days ago, is that I will be in touch with every minister in the Cabinet to make sure that they have the systems in place that will properly respect and protect privacy.
How much time? Okay. On this, just to carry this out, a number of people, or I'll even go back to my own personal. I'm a private person. I want my rights protected. I want all Canadians' rights. But we live in a different world today, Mr. Minister, than we did even 10 years ago. And what I mean by that is the threats that are out there. Mr. Spengman talked about domestic terrorism. There's no doubt it's more prominent today than ever. So, you know, it comes back to the thing. Well, I like my privacy, and I think most Canadians do. At the end of the day, I find it a small sacrifice that if our agencies that protect us all have tools to actually do the job, and also, if I have done nothing wrong, I have nothing to worry about. And, you know, and I've had that said to me. I'm sure you've had some of your constituents tell you that. And how do you respond to that?
Thank you, Mr. Miller. On continue avec M. Dubé.
We're going to continue with Mr. Dubé. Thank you, Mr. Chairman. Minister, thank you for being with us today. I would like to come back to the election platform because I have an excerpt in front of me, and you listed the changes that will be made, and they do come from the platform. But after that list, we read the following. Upon tabling these legislative measures in Parliament, we will launch vast, broad public consultations to get to know the opinion of Canadians and experts. What we had understood was that there was going to be a bill put forward and then Canadians would be consulted. And now we see that there's consultation that is planned, but there are breaches, failures, problems that have been mentioned even by the Commissioner. So nothing is being done. There's not enough surveillance. It's not adequate. And what's the situation going to be? You're going to be tabling a bill to bring changes to C-51. Why not simply respect your commitment in the platform to table a bill containing the measures you're putting forward and then consult afterwards? Because clearly you've already made up your mind. You've already listed a series of things that match perfectly the platform.
The fundamental cornerstone commitment that we made in the platform was the creation of the new Committee of Parliamentarians. And that piece of legislation is now before Parliament. And it will undoubtedly be thoroughly analyzed by this committee and by the public in the process. There are several other commitments in the platform. It may well take 2 or 3 different pieces of legislation to work our way through all of them. But we are moving in a very measured and logical way to deal with the defects that we found in C-51, to bring this whole new architecture, including the Committee of Parliamentarians, and in the process, to give Canadians the chance to be heard that they were denied
Minister,
previously.
if I may, you'll understand my time's limited, but my question is, there's 7 bullet points here on the Liberal Party website that were you committed to fixing C-51. And the paragraph at the end of those bullets, and only one of those bullets is the Oversight Committee, there's a specific mention that we will consult Canadians after presenting legislation, which has not been done. So the concern I'm raising, that I think is very serious, especially in light of the Privacy Commissioner's report, is that these powers continue to be used. The problems have not been fixed. This committee has not been put in place yet. We're a year into your government's mandate, and I understand the bill's moving through the House. That's fine, and there's problems with that, and we'll get to that. But the fact is, why is there no legislation, and how can we trust these consultations when, beyond the criticisms that have been raised by the Privacy Commissioner and others that we've heard from, how can we trust that when there's already a list that was committed to in the election and that you yourself just enumerated in your presentation?
Well, as I say, the cornerstone piece of legislation is in the public domain. There are also 2 others that I would point out dealing with the cross-border issues with the United States. That legislation has been prepared and published. We are now conducting the necessary consultation, in addition to the list of specific things that I mentioned, to ask Canadians the key question: is there something else that you want included or you think is valuable to be included in the reform package for the accomplishment of two objectives: keeping Canadians safe and making sure that our rights and freedoms are safeguarded. This is a process that we began to work at immediately after the election. It's a huge, complex area. We're going at it in a thorough and logical way, and I might point out that the reason why previous governments got into jackpots on these issues is that they tended to scribble down policy on the back of an envelope and didn't do the proper consultation in advance.
You voted for that policy, though. That's what I don't understand. Et quand je lis le rapport du commissaire, on lit toutes les...
And when I read the commissioner's report, it talks about the levels that are not appropriate, etc. The commissioner, in his presentation that he made on Tuesday, he could have made the same presentation during the last Parliament, and he would have been saying the same things. Our great concern is that the consultation process, well, we're just putting it off and putting it off over and over and again, but Canadians' rights are threatened. In the meantime, these powers are being used. We see the failings here, the deficiencies, and the legislation is being used. People are saying that the process seems to be dealing mostly with the strengths of the Act and not the protection of privacy. A lot of experts have been saying this, and it seems that we've already reached some conclusion if we read between the lines.
Differ, Mr. Dubé. The process is not by any means being preempted. I mean, in a sense, your argument is a bit contradictory because you're saying introduce legislation and consult later.
I'm just asking you to respect your election commitments.
And what
Ours
I'm
is
saying
clear. We want
is
to
the
repeal
core piece of
C-51.
legislation has been implemented, has been introduced. It's Bill C-22. There will be perhaps 2 or 3 other bills that will come later on. Obviously, the ones dealing with the specific commitments in the platform, but it is useful to ask Canadians what else they want to see considered. Indeed, the Privacy Commissioner's items are not included on the list of the first 7. So the consultation has already yielded results by bringing forward his perspective on that particular issue. Other people have said you need to deal with the deficiencies in peace bonds. That is a critical deficiency as well, and we learned in the Strathroy case that the peace bonds that were described a couple of years ago as being kind of a panacea solution aren't, and they need to be fixed.
And many say part of the problem there is that police don't have resources, and that the reality is C-51 wasn't even necessary, because if law enforcement actually had the resources, and if there actually was a counter-radicalization strategy, then we wouldn't even be debating C-51 now, that those are the actual tools that would really make a difference. Do you agree with that?
And we're moving on all of those fronts.
Well, it seems like we're consulting a lot, but you have specific proposals. How can you convince Canadians that it's not already a foregone conclusion? When right on the Liberal website, it's there.
Those specific proposals are the minimum we will do in the changes to legislation. What we're asking Canadians in the consultation is what else do you think need to be added to that list? And Canadians have already added to the list. They've added issues around privacy, they've added issues around peace bonds, and they've in the 8,000 submissions that we've had, have added a good many other ideas as well. It's useful to ask Canadians what they think, because they'll always give you useful information.
Merci.
Thank you.
Minister and Mr. Dubé. On continue avec Mr. Diorio.
Continue with Mr. Diorio. Minister, thank you for your statement, your opening statement. We've been waiting to meet with you for quite some time. First off, I would like to hear you tell us about the dangers there are for Canadians. I understand that there can be differences between regions, but might you possibly indicate what the risks are? You mentioned one. Are there other dangers looming presently for Canadian society?
Refer you, I think, broadly to the threat assessment report, because that goes through in detail where we feel the principal threats are located. As I said, the key one is the inspired lone wolf that is perhaps the most difficult to defend against. because they tend to act in isolation. If you've got a terrorist organization that is plotting some grand scheme, like, for example, the attack on Paris almost a year ago, an enterprise like that tends to involve a sufficient number of people in a significant amount of planning activity that they tend to leave tracks, and evidence can accumulate. In the case of the Lone Wolf, there's not that kind of activity. They tend to be isolated. They're not using sophisticated weaponry, but they're still dangerous. And we saw that in Strathroy this summer because it was a prime example of that kind of problem, and it can happen all across the country.
Une importante préoccupation, Monsieur le Ministre.
A grave concern, Minister, is the dilemma facing Canadian society. On the one hand, we have individuals who want to commit dangerous acts, who are going to commit violent acts against Canadian society. And then we have the police forces, law enforcement, who are combating this. But the dilemma is the following. The bad guys, those who want to commit these violent acts, by their very nature don't inform the population, the people, of what they plan on doing. So we can't know what they're preparing. On the other hand, we have the law enforcement people who don't want to divulge the nature of their investigations to not hinder them. And I would like you to enlighten the committee. How can we navigate faced with this dilemma in order to adequately inform Canadian society with regard to the dangers and threats it's facing?
Part of it, it can be through a consultative process like this one. Part of the answer is making sure that our security and intelligence and police agencies have the right kind of independent oversight. And we'll be adding to that through the Committee of Parliamentarians. But already, there is oversight provided in most cases, not all, and that's another issue that we need to address in this consultation process, where there are gaps in the oversight mechanisms, like, for example, with respect to CBSA, which does not have an agency providing oversight like CERC provides for CSIS, or the CRCC provides to the RCMP, or the Commissioner that provides oversight to the Communications Establishment in National Defence. If you read the reports of those agencies, and CERC just published their report a week ago, it is a very interesting overview of CSIS's activities in the last fiscal year, and it shows you the kinds of things that they've been looking into, the kinds of activities they've been conducting both in Canada and abroad, and where the activities of the agency could potentially be upgraded. But this oversight function is, as I think, can be very helpful to the public in understanding what the agencies are doing, and that in the process of doing that, they are effective and they are safeguarding Canadian rights and freedoms. So I would commend to you those detailed reports by the oversight agencies, and ultimately, when we add the Committee of Parliamentarians, that overview coming at least annually from a committee of 9 parliamentarians will add another dimension to Canadians' ability to understand what our various police, security, and intelligence operations are doing.
Je vous remercie, Monsieur le Ministre. Un autre élément.
Thank you, Minister. Another element. Canada is a federation, so there is constitutional sharing, legislative sharing. You talk about exchanging information, sharing information between federal agencies. How can we ensure that the provincial agencies, the provincial authorities, are also sharing information amongst themselves and with federal authorities?
Jurisdiction is federal, so we've got to be careful to to respect the Constitution in that regard. But there is very effective cooperation among all the levels of police forces in the country. To go back to the incident on the 10th of August at Strathroy, Ontario, the first people to be notified, of course, were the RCMP. But as they went about identifying the identity and the location of this particular individual, Aaron Driver, they engaged the city police force in London and the regional local community police force in Strathroy, Caradoc, and the Ontario Provincial Police. So you had federal, provincial, and 2 municipal police forces collaborating very effectively together. It was a seamless operation, and you actually add a 5th level to that because the original information came from the FBI in the United States. So that was a classic illustration of how our various forces and agencies communicate with each other and cooperate with each other to make sure that we're keeping Canadians safe.
Thank you, Minister. On continue dans le deuxième tour avec
We move on to the second round now with Mr. Brassard.
Here today, the Globe and Mail reported yesterday that in an essay you wrote this week that you said that Bill C-22 creates a committee that will set its own agenda and report when it sees fit. Yet, in an independent report by the Library of Parliament, they stated how much the committee members would be able to access state secrets is in question because the legislation would allow cabinet ministers to block reviews of some spy programs and thwart the committee's bid to see sensitive document. Bill C-22 authorizes ministers to refuse to provide information. Now, we know that there are 7 exemptions that are in place within the legislation. We also know that there was an issue back in 2010 where Speaker Milliken ruled on a question of privilege, and he ruled that it was quite clear in his ruling that the fact that there was sensitive information or intelligence documents or information relating to an ongoing investigation did not remove the obligation of the government to share those documents with the House. In fact, you said in support of that ruling that the series of questions of privileges resulted in your ruling on April 27th, when in very eloquent terms you indicated that Parliament did have the right to this information. As a committee of Parliament, what's changed, Minister?
If you read the entire judgment from Speaker Milliken, you'll see that he put national security,
national defense, international
protections in place in the very structure of his ruling. The point is this: with the greatest of respect to the author of that report from the Library of Parliament, I would respectfully disagree with his conclusions. But
so can I
know
ask
we're
you
not
then, Minister,
discussing
can
Bill
I ask you
C-22.
then, Minister,
just a second. I want to answer your first question before you get
and
on.
I want to ask
go
you
on to
another
the second
question,
one.
so be brief,
The point, well, if you want an answer to the question, it takes a little time. Bill C-22, which I gather we are discussing today, Mr. Chair, even though we weren't supposed to be, but that's fine. Bill C-22 provides this.
We'll try to keep C-22 to a minimum in this debate. We will be having you back at C-22 in a few weeks, so if we can keep, and I'll give you extra time because I've taken your time, but let's try to keep C-22 down to a minimum.
Okay. Bill C-22 provides to this Canadian Committee of Parliamentarians more authority, more scope, and more power than almost any of its counterparts in any of our allied countries. It will have more jurisdiction to provide a higher level of oversight, and the intervention of a minister or the Prime Minister is limited only to those cases where the particular review at a particular point in time would be injurious to national security. And on those grounds, a minister or the Prime Minister could intervene to say, not this particular area at this moment in time, but they would have to give written reasons to the committee for why they were making that judgment.
Can I ask, Mr. Chair, how much time we have left? Okay, so when you say that it will set its own agenda and report when it sees fit, what do you mean by that?
It can look at any activity in the Government of Canada. It can ask for any information within the Government of Canada. It is required by the statute, the draft statute, to report at least once a year. It's entitled to report any other time that it thinks it's appropriate. And if this committee finds something in the national security activities or architecture of the government that it thinks is wrong, either not effectively keeping Canadians safe or not respecting Canadians' rights and freedoms, then the committee is perfectly at liberty to blow the whistle. They cannot divulge classified information, and I presume no one around the table would argue that they should. Classified information needs to be classified. But if they say publicly, and if you've got 7 MPs and 2 senators, it's certainly going to be public. If they say publicly that something here is wrong, even without divulging the classified detail, they can blow a whistle that will make it exceedingly uncomfortable for the government of the day. And that whistle will keep being blown until the problem is solved. They've got a bully pulpit like no other.
Thank you, Minister.
Mr. Erskine-Smith.
Thank you for attending, Minister. I want to start with a simple premise that when we limit Canadians' rights, we have to justify that those limits are necessary. And I want to speak to threat disruption or threat reduction powers specifically. And can you speak to the necessity for these powers and what was wrong with the previous regime and why these disruption powers are necessary?
Well, Mr. Erskine-Smith, that's exactly the reason why we're having the consultation.
Fair enough.
Because we want to hear Canadians on this topic. They didn't have a full opportunity to be heard before. We're giving them that opportunity now.
That's absolutely fair. And so in the interim, while consultations are ongoing, I recognize that obviously you have restricted the ability of CSIS or CSIS has agreed to not seek a warrant to violate charter rights. However, there have been dozens of opportunities, if not more, of CSIS engaging in threat disruption, threat reduction powers. And what assurances can we give to Canadians that their rights are being protected in the interim?
Well, the report from CIRC, the Security Intelligence Review Committee, tabled last week, indicated that not only had no threat disruption activity that would have required a warrant been undertaken, no warrant was even asked for.
But there are threat disruption activities that have been undertaken without a warrant. And so those threat disruption activities presumably
are completely consistent with the law and completely consistent with the Charter.
And they are reviewed by any...
By CIRC. Indeed, that's one of the requirements of the Security Intelligence Review Committee, to review those activities every year. And that may be one thing that the new committee of parliamentarians would want to delve into on a regular basis as well.
It's a good segue to the issue of oversight. And obviously, the RCMP, CSIS, and CSE are each subject to oversight, review bodies, I should say. CBSA, you noted in response to a previous question, is not. And a number of, quite a bit of the academic literature suggests that this silo effect, we have a whole of government security, but we don't have whole of government review. And I wonder if you could speak to the necessity of whole of government review in your experience today.
Well, a very good point and a very good question. One of the virtues of the way we have structured the Committee of Parliamentarians is that it is not in any silo. When the British review mechanism was established, for example, there are 4 specific agencies that the British committee can look at. None others, just 4. In the Canadian model, we have made it government-wide. This committee will have, first of all, access to classified information that has never before been made available to parliamentarians. And secondly, they can follow the information wherever it leads, from agency to agency, department, wherever it goes in the government. They are entitled to look at all of it.
So without getting into C-22 and parliamentary oversight, but specific to expert review, and the academic literature suggests that in addition to parliamentary oversight and review, in addition to the three review bodies, a super circ, as it were, is likely necessary. And if you could speak to that specifically.
That is an idea that I want very much to examine in this consultation process. Because there are gaps in the architecture. You pointed out, as I did, CBSA. There are others. And you need the expert analysis, and you need the parliamentary analysis. And since we've never had the parliamentary analysis before, there'll be some working out here of how the two interconnect with each other. But both are required, and we have to find a way to get out of the silos. The parliamentary committee, by definition, is out of the silos. The review bodies below them are still limited, and we'll have to examine how you get that cross-fertilization.
One final question with respect to information sharing. The Privacy Commissioner attended before another committee. I sit on the Privacy Committee and suggested that he was not completely clear on how much information had been shared under the new Act. The departments hadn't all been completely forthcoming in a timely manner with his office, and I wonder if you could give some assurances to Canadians that you're seized with this matter.
Yeah, I was concerned with the Privacy Commissioner's comments. As I said earlier, I consider him to be an essential part of the oversight apparatus, and I take his advice very seriously. And as a first step, I'm in the process of writing to all of my cabinet colleagues to remind them of the obligations that are imposed on departments by virtue of the new legislation, and to make sure that they have the right privacy protections in place. And the Privacy Commissioner is usually very forthcoming in providing advice about what he thinks is necessary to fix problems.
Thank you, Minister. On continue avec Monsieur Généreux.
We'll move on to Mr. Généreux now. Thank you, Mr. Chairman. Minister, thank you very much for being here today. As you know, we've already undertaken the consultation process, and in the Green Book, that is the basis for the consultation work, we heard two witnesses this morning. The Privacy Commissioner, also a professor, Professor Ward, who told us, basically, that upon reading the Green Book, he found that the whole issue of the digital world, everything involving digital information for national security, has been underestimated. And not emphasis has been placed on it in the Green Book. And to paraphrase your boss, we're in 2016. And I think this is an extremely important aspect, and we shouldn't underestimate the threats for Canada, especially the use of media, social media, and digital media today to potentially threaten our security. I would like to hear your views on this, because in the Green Book, you signed it, so I imagine that you're well aware of what it contains.
Three different consultations going on with respect to cyber issues and digital issues. Obviously, that's included in part in the National Security Review that I'm responsible for. At the same time, we have a focused discussion with industry and with the public on cyber security issues and the protection of critical Canadian infrastructure. That's going on at the same time in a different forum, but a parallel study. And in addition to that, cyber issues are also covered in the National Defence Review that my colleague, the Minister of National Defence, is conducting. So it's a cross-cutting issue. It's not just in one department or one dimension of government. Cyber issues cut across the whole span of government and private sector operations. It's a field that is rapidly evolving, and we need to make sure that our cyber policy is up to speed. The last cyber policy in Canada, I think, was 2010, I believe, even in the span of 4 or 5 years. It's generally regarded now as outdated. It was thought to be, in 2010, quite avant-garde, ahead of the curve. But cyber issues have evolved so dramatically that we're not as up to speed as we ought to be. And that's why we're looking at it from the point of view of public safety, from the point of industry and the private sector, and from the point of view of national defense.
Okay, à ce moment-là, dans le cadre de notre étude à nous,
In the context of our study, then, is there something you would like us to look at more closely? Would you like us to move in one given direction to get further information on a particular issue? Within the committee, we're interested in all security issues. Are there aspects that you would like to see covered in an eventual report? Some issues might be more important in your opinion than others.
Number of issues you might tackle. But one, and it is referred to in the paper, is this phenomenon that police and security agencies call going dark. When the activities of would-be criminals or would-be terrorists are so technically encrypted from beginning to end that there is no ability or very limited ability to detect the activities of those who would pose a threat to public safety or national security. That issue.
est-ce que vous savez s'il y a des organismes?
Do you know if there are organizations, terrorist organizations, that go dark? Is that what you said? Going dark? Is that the term?
Dark, yes. Which means if you're an investigator, all of a sudden, all of your access to information evaporates because the material is so heavily, not only the material, but the systems that carry the material are so heavily encrypted, you are not able to even detect the trail that you might like to follow. And that's a huge issue that is both technological on one side and legal and constitutional on the other side. And it would be very useful to hear the debate in the committee and the evidence of the witnesses that you might call to delve more deeply into that very critical field. And it's a field that had a bearing on the ability or not to detect the activities of Mr. Driver.
Thank you, Minister. We're almost at our time. We have one questioner left. I can give you about a minute and a half.
Thank you, Minister. It's always good to see you at committee, and I want to commend you for leading Canada's first ever public consultation on national security. Truly historic. I have time for one question, and I want to relate to counter-radicalization. Can you tell this committee what, if any, partnerships you see with social media outlets like Facebook, Twitter, Instagram, where there is sadly, regrettably, a lot of non-sanctionable speech which crosses the Rubicon into inciting terrorist activity? What kind of partnerships you see going forward so that we can stymie the spread of that?
The whole effort in terms of community outreach and counter-radicalization will need to be built on partnerships. The federal government can establish a center of excellence. We can pay for research. We can promote coordination and cooperation. But the actual activity that will make a difference in heading off that cycle into violence will be at the community level with religious and social organizations, with the private sector, like those who are very good at communicating. And we are going to have to consult with them very, very carefully to get their advice about what is the right way to intervene and what is the right message that intervenes most effectively with the right people at the right time at the right place in order to head off a tragedy. So partnerships with community organizations and with private enterprises that have expertise in this field will be absolutely critical.
Thanks very much, Minister.
Thank you, Minister, and thank you for your time with the committee. We expect to see you in a few weeks. We have the honour of having your deputy staying with us as other officials come in. Let's take a moment as we just pause and let the minister get out and have other witnesses. Thank you very much. So, committee, I know you'll be very pleased that we're going to get right to questioning, that the opening statement was done by the minister, and we now have witnesses coming, continuing Mr. Brown from the department, as well as Ms. Beauregard, and Mr. Coulombe. Welcome again from CSIS, and Mr. Paulson. Nice to see you back. Thank you for taking the time to join us. As you know, we are beginning a fairly large study of the national security framework. This is not a legislative study. It is a study of parliamentarians on the whole framework, which we hope will help advise the minister as he considers both policy and legislative changes in the coming years. So that is the nature of our work. We're not dealing particularly with any legislation. We will be dealing with C-22 now that it's been referred to us. C-21 and 23 we expect, if they should pass in the House, will come to us. But this is really much at the theoretical level of what it is that we as parliamentarians need to be advising the minister on, having listened to both the agencies and then Canadians. We're going to begin this round of questioning. We have a round of 7-minute questions, and Ms. Demoff will continue. Welcome, Ms. Khaled. Glad to have you step in, and Ms. Taylor as well. Thank you for joining us.
Thank you all for coming. Just if the chair will indulge me for just a moment, I wanted to, Commissioner Paulson, when you appeared before, I certainly had asked you about harassment in the RCMP. I just want to publicly thank you for your announcement this morning, and it was historic, and I want to thank you for that, and I'm very hopeful, as I know you are, that this will turn a page in a new chapter for the RCMP, so thank you for that.
Thank you.
My first question, I also sit on the Vice Chair of the Status of Women Committee, and we heard recently from Carol Todd, whose daughter Amanda was experienced cyber violence from a predator in the Netherlands, and it sort of ties in when we're talking about issues with cybersecurity. Ms. Beauregard, when you appeared before the committee before, my colleague Mr. Spiegelman had asked you about a strategy to deal with these threats that are both domestic and international, because when we're dealing with the internet, it's no longer, it's not a country, it's international. And there were certainly challenges in that young lady's case in terms of dealing with the issues. And I wondered, when you responded, you had said that we didn't necessarily have a strategy in place. And I'm wondering if you could maybe elaborate a little bit more on what we need to do, also bearing in mind respecting privacy of Canadians, but in particular on the international, how we can best deal with that.
Thank you very much for the question. So on the issue of cyber crime, cyberbullying and all that, as the Minister pointed out, we have currently also a consultation ongoing on the best ways to secure ourselves online. Specifically, the issue of cyberbullying and cybercrime has manifested itself as a fairly significant preoccupation. And since then, we have, before going online with the cyber review, we did modify it to include a fairly significant chapter that would address cyberbullying, cybercrime, and all that.
But not just with cyber violence, though. I would suspect that even with issues of terrorism, you'd be running into the same types. I know this sounds terrible in here, isn't it? You'd be running into the same types of issues in terms of I mean, we had the gentleman from the Association of Chiefs of Police who talked about how it takes 18 months to get evidence through signatories to the Mutual Legal Assistance Treaty. Do you run into that with terrorism threats as well?
So, on that, really the Foreign Affairs, GAC is the department that leads all of the efforts with respect to international cooperation. What I was trying to get to is that as part of the cyber review, we are looking for feedback on how we can improve both domestically and internationally our measures to fight that. So you indicated that we don't have a strategy. at this point. This is something that we are looking forward to establish with the end of the consultation. The consultation closes at the end of the month, so by then we will have collected the feedback from all the stakeholders. As well, we've consulted with our international close allies on this issue, and all that will be then forwarded to Cabinet with all of the results of the consultation will be forwarded to the Cabinet.
Okay, thank you. At our last meeting, we heard a lot about metadata and how collection can impact privacy. I didn't have an opportunity to ask a question, but I would suspect most Canadians don't even know what that is. Can someone perhaps elaborate a little bit on that and how it's collected and how it does impact on our privacy?
I think, frankly, the collection of metadata is, to the extent to which it's undertaken, and you really need to turn that question to our colleagues at CSE. I don't think there is a huge amount of metadata that is collected. Generally speaking, and I'll let my colleagues to my left correct me, it is essentially data that is the equivalent of non-personalized information about a device, the length of time, where that device is, and that kind of thing. But colleagues, either of you want to take a stab at that?
Well, I'll give you an example, an email. Metadata would be IP address, everything except the content of the actual email. So email address, IP address, phone number would be, in the case of an email, but phone number would be. To go back to the old mail, it would be what you would find on the envelope, not the content of what's in that envelope.
So the privacy...
It's probably, my colleague from CSE would probably say it's a pretty crude description of metadata.
She would.
But the Privacy Commissioner did express privacy concerns about the sharing of that data. So you're saying it's similar to what's on an envelope?
Well, so I would say that the Privacy Commissioner's concerns come from the raw collection of metadata from which certain trends or behaviors or conclusions about movements and so on can be deduced. We don't do that, and if we do it, we do it through warrant. And similar to our friends at the service. So that's how we manage that.
Okay.
So it's not trying to pass the buck here, but I think if there are those kinds of questions about the sort of theory around metadata, it'd be more helpful if you had the experts from CSE try and answer your question.
Thank you, and I think that's my time. Thank you for being here.
That's very helpful because as we've been looking at our witnesses, we had thought about CEC, then kind of put them aside because they relate to other branches of government that we don't deal with. But I suspect that that's helpful for us to now include them on our witness list. So thank you for that. Mr. Miller.
Thank you, Mr. Chair, and to our witnesses here today. Thanks very much for being here. I want to start, Mr. Colomb, with you. You appeared before us Senate Committee on National Security and Defense, and afterwards you issued a statement where you recognized some statistics regarding current intelligence on individuals, and I believe that statement said that CSIS is aware of approximately 180 individuals who have traveled from Canada to participate in terror activities abroad, and you're also aware of approximately 60 individuals, that's probably changed a bit, who have returned home from abroad. So I have three questions on that. Number one, why haven't these individuals been arrested? Two, are there ongoing investigations on those individuals? And what is the evidence threshold to detain them?
Thank you for the question. Sorry. But actually, two of the three questions are more law enforcement, so for the commissioner. In terms of it's a second question, though, in terms of ongoing investigation, I've also testified that I'm talking about the 60 returnees, it's important to understand that a returnee, somebody coming back from overseas who participated in terrorist-related activities, pose a potential threat because they're not all the same. Some of them will come back and just go back to normal life. Some will continue to be engaged in threat-related activities. So we have ongoing investigation on some of them. But again, it depends on the type of activities they're involved since they came back.
Would it be half of them that investigations? Do you have any numbers?
Not off the top of my head. I couldn't say of the 60 how many are.
Sure, fair enough. Mr. Paulson?
So we'll investigate anyone for whom we have a reasonable suspicion that there is a criminal offense being committed. Mm-hmm. The threshold for bringing charges, though, is a different question. We can arrest someone on reasonable grounds to believe, but we need the support of the prosecution service in order to bring A, Attorney General consent to a terrorism charge, and B, to support a prosecution. So there's an analysis that takes place, because if we were to arrest them, we could only hold them for 24 hours unless we made the case through the recognizance provisions of C-51 that we could hold them longer. But we try to build a case that wins in court. And now we enter into the discussion about the spectrum of activities that we collectively engage in to manage the threat, ranging from surveillance to continued investigation, interviews, peace bonds, et cetera, But there's nobody, we have many active investigations, as do our colleagues at the service, and there's no one out there for whom we have evidence to bring a charge that we're not charging.
Okay, I'm happy to hear that. You mentioned there the fact that you're only allowed to detain somebody for 24 hours. Has that changed with C-51?
Sorry. Yes, it has, but it brings with it new conditions that we would have to satisfy. In order to extend past the 24 hours, we would have to appear before a judge and make the case that there is a need to detain him past 24 hours as we collected evidence and so on. So the provisions for the recognizance, or the delayed or continued detention, rather, come from the realization that the so-called flash to bang time, in other words, when we learn about terrorists and when they commit the act, has compressed over the years. I think that's everyone's experience internationally, certainly domestically. And so we realize that we might not have a presentable case in time, because it's very, complex and logistically onerous to bring a case and persuade another human about the facts in a case.
Okay, my next question, just carrying on, is it now easier or more difficult to get a peace bond? Can you comment on that?
Well, it's supposed to be easier. That's not the answer to the question.
Is that a good thing?
Well, it's supposed to be easier, but I think great care has to be taken in terms of how it is a good thing. I think it is a good thing. As I said once, in the right circumstances, it's the only pre-charge sort of control that the state can exercise over a suspect, right? Short of a recognizance, or if there was a conviction over a probation order and so on. I think it's a good thing. I think that it's not well understood by Canadians. It's not well understood by a lot of people in terms of what it is. It certainly isn't the panacea, but it's a good thing.
Okay. After Louise Vincent, which is sister of Warrant Officer Patrice Vincent, who was killed, I believe, in the Montreal area, she appeared before the Public Safety Committee, and she stated that the RCMP had not been able to get a peace bond against Martin Couture-Rouleau due to a high evidence threshold. So has that changed? Is that true? Can you comment on that?
Yeah, I can. I think that, to be fair to everyone who was working in that case on Couture-Rouleau, we had not, we didn't obtain a peace bond on Couture-Rouleau. And I think it's easier since then to get a peace bond. Certainly the threshold has changed. I mean, the C-51 provides for a lesser threshold, which is a reasonable fear.
Okay, I'm running out of time. There's a private member's bill before the House to define variant, which is named 97 times in the Firearms Act. Would that bill be helpful to the RCMP?
I don't know. I can't answer that. I'm not in a position to answer that.
One last quick question. Just going back to what we were discussing just before that last question, would Officer Vincent, in your opinion, still be alive had Bill C-51 been in place?
Yeah, I don't think I can answer that either.
Okay. Am I 12 seconds? Again, yeah, the reason I asked that is because a couple people in law enforcement had said as much, and, it might have been opinion, but I just wanted to hear your answer on it. Thank you.
La prochaine, Mr. Dubé.
We now move to Mr. Dubé. Thank you, Mr. Chairman. Welcome to all of you. Thank you for being with us. Mr. Coulombe, I have before me the directive that the Minister shared with your predecessor with regard to information sharing, more specifically with regard to ill treatment, bad treatment, in other words, torture. What concerns Madame Laverdiere, my colleague, and myself is this. There's a section that I'll quote. Generally speaking, which is quite vague, CSIS cannot consciously use information obtained through torture in foreign countries. In exceptional circumstances, it says CSIS can communicate any information it has, including that obtained by a foreign organization, most probably obtained through ill treatment. Can you guarantee to us that we're not using information obtained under torture? Because I believe that this is something that Canadians would find unacceptable. Second part of my question, would you agree with us that this type of directive should be changed? You want to ensure our protection, but we want to also safeguard our values, and this doesn't fit with our values. What I can guarantee, and if you look at the annual report of CERC that was tabled recently, they indeed looked at all of this issue of information sharing with foreign partners. And CERC found that the service, after that directive came out, put in place governance of policies in order to ensure that we follow the law and also comply with the ministerial directive. This includes a high-level committee that meets to assess the risks of ill treatment, torture. Were we to share information, it assesses the information, if we do receive this information, to determine if it was obtained under torture, and it also must decide if we are to use the information or not. And if that determination is that there's a high risk, then the final decision to share the information or to use information received, well, that decision resides with me. And here again, CERC did indeed say that the service did put in place a rigorous structure in order to respect its obligations with regard to ill treatment and also to protect Canadians, because that's our first mandate. And just to answer quickly your second question, I would say that this is a small p policy issue for the government and for parliamentarians. It's up to them to decide and debate. When we talk about the discretionary aspect, however, from what we've read, the information we might obtain under torture, well, it's deemed to be ineffective in virtually 100% of cases. So this won't ensure the security and safety of Canadians if that's the case. So is there really any true need to obtain information obtained under torture? Well, when we say information obtained via ill treatment, when people say it's not usually reliable, I'm not here to contradict that. But the fact is that if we have information obtained under torture, we're aware of the fact that it can be unreliable. And we will try to corroborate this information via other sources. Also, will we keep this information for ourselves when police forces might be able to use it to prevent some actions, some acts that might be in the planning stages. So we take that into account with regard to the measures that we'll take. In other words, to corroborate the information via other sources or to make some other use of the information, knowing that there is a reliability issue at play. But to simply reject outright the information, if there is a threat to Canadians, if it's high and imminent, this threat, well, I believe that for the service that would be irresponsible. If we look at the situation with regard to information sharing with consular services under C-51, with our new Foreign Affairs Department that's been renamed, how can we be assured and reassured that we won't see a repeat of Maher Arar's case, for example? Because we don't discredit the information obtained under torture, but with C-51, there are agreements by virtue of which we obtain information on Canadians detained in foreign countries, possibly in similar circumstances. How can Canadians be assured that the information you're sharing hasn't been obtained under torture so that we don't relive that we saw with Mr. Arar? We were expecting great reforms. First of all, contrary to the situation 3 years ago and even last year, there is legislation framing the use of that information in the specific case you mentioned between foreign affairs, world affairs, global affairs, and the service. So there is legislation in place. The service, and this was reported in the media, and global affairs recently signed a protocol. But if you'll allow me, sorry for the interruption, but I don't have much time. Specific protections under the law to avoid a repeat of that situation. What exactly is it? Well, the Information Sharing Act that flowed from C-51 says that, first of all, it's not an act that forces other departments to come on board, but there is an agreement in place. It remains voluntary. It was to facilitate things. But as far as protection goes, it says that the agency that will provide the information must ensure that the information is relevant and fits with the mandate of the organization that will receive the information. In that spirit,
in front of me, if we talk about the threshold that exists where relevant versus necessary, I think that's what we've got it into. And the Privacy Commissioner said that that threshold should be changed. So basically, the situation we're now in is that information is subject to a lower threshold, so there really isn't a very large legal protection to avoid a similar situation like we've seen in the past.
Well, I'm not in a position to debate the legal threshold, but the other protection we haven't talked about, and I've just mentioned it, is the fact that the Privacy Commissioner can review the information that was exchanged. In the case of the service, CERC can review all the information that we received through what is known as CISA, the act that came through C-51. So I believe there is protection. Now, should the threshold be higher or lower? Again, that's a policy decision for parliamentarian and the government.
Merci.
Thank you.
I wanted to start with a quick question from Mr. Coulombe on disruption powers, just to update the committee on the number of times that the new threat reduction powers have been used.
I think it was in February that I was in front of this committee, and at the time, I believe I've mentioned something around 24, if I'm correct. Since that time, actually, my answer will be the same because we're not doing a huge number of them. And so it could have been 18 at the time, now it's 20.
Might be 20.
Might be 20.
Might be 20.
Yeah, might be 20.
Okay. With respect...
But I just want an important point to specify. All of them didn't require federal court warrants.
Understood. Because you weren't seeking to deal with the charter anyway, and we heard that from the minister. With respect to these disruption powers, I just want to get at the heart of this. So can you speak to why these powers are necessary and perhaps give specific examples of where the pre-C-51 powers were insufficient and why existing law enforcement powers are insufficient?
Well, the service is because of our mandate, our threshold to investigate is lower. So we're in the position to, at the very emergence of a threat, to be there and to see the evolution. And like the Commissioner just mentioned, that evolution today from planning to execution, from radicalization to mobilizing to use violence, that time is extremely short. And threat reduction can be useful in scenarios where we want to, as soon as possible, reduce that threat. So, and that's something we couldn't do before.
But so what I'm trying to get at, I mean, threat reduction is a very broad term. I know in other countries they actually specify the powers in a more, in a less vague way, to put it politely. So specifically, what are examples for Canadians to know when we say threat disruption, threat reduction? What are we talking about?
Well, there's actually an example in the green paper, and I think when I've testified previously, I gave example of non-warranted can be as simple as asking somebody to intervene because a young person is on the path to radicalization and mobilizing to violence. It could be informing the parents that his kid is on that path. It can be actually advising social media that a user is breaching their rules. The service will not take down the account, then it's up to the social media to actually do it. Those simple things, we couldn't do them before.
Now, if we go back to 81, the McDonald Commission, obviously they found that security intelligence should be separated by police work. Could you speak to One Vision 2.0, give a quick explanation of that to the committee, and could you speak to whether that One Vision 2.0 and the requirement for collaboration and notification as between RCMP and CSIS, whether we should codify that? Whether that should be long-standing, that we should codify that.
Well, you mean the relationship, the
One Vision 2.0. Give it a brief explanation. Is it working? Is it something we should keep?
It's a framework, and you can jump in. It's a framework for CSIS personnel and the RCMP how to, when we're looking at the same investigation, how to do this. To make sure that there's no duplication, no gaps. Also, that extremely important for us, that there's no, whatever we're going to be doing will not have a negative impact on the criminal investigation further down the road, the criminal prosecution.
So you're not having two separate parallel tracks, but you're in communication.
Exactly.
Okay. Moving to Commissioner Paulson, preventative arrest and the expansion of preventative arrest. You mentioned a lowering of the threshold. Is that lowering of the threshold necessary? Has this preventative arrest power been used since C-51?
No, it has not been used.
Yeah.
I would continue to argue that it's sure nice to have, given how we understand the threat, because of what I described, as my colleague described as well, the difficulties that we have in getting the information, complex as it is, unpacked as it often needs to be, and presented, coherently to a prosecutor to be able to make all the decisions. It takes a lot of time. So that's the advantage in my mind.
Since it hasn't been used, then it's fair to say we don't really have any evidence that lowering of the threshold was necessary, or that the increase from 3 to 7 days was necessary.
Well, we don't have any evidence different from what we had to have it changed in the first place.
Okay. I'd asked the minister about a Super Circ, a larger review body, and curious, you would have no position on this. You would have no. I mean, obviously there are review bodies already that govern CSIS, that govern the RCMP, and a Super Circ, as it were, that can share information and match whole of government security with whole government review. You would be supportive of that? You would have no issue with it?
Well, I don't take any issue with any oversight. I think the need to coordinate the oversight, because there is no shortage of oversight in my mind. I think the need to coordinate it and to have it coherent, to overuse the word, is important.
Yeah, so the existing review bodies would coordinate together. Perhaps we would pull the CVSA into the review as well. Mr. Colomb, would you have any thoughts on that?
Again, that's a policy issue to be decided by government, and the service will, whatever tools are put in place, review, oversight, the service
no issue
will
with
cooperate and work within that framework.
Perfect. There's a definition of in the SCISA, activity that undermines the security of Canada, and it's a very different definition from that in the CSIS Act, threats to the security of Canada. Mr. Colomb, you'd have no issue if we stuck with the threats to the security of Canada definition in the CSIS Act? That's the one you've always operated under?
Well, I'll talk about the CSIS Act. We continue. SCISA didn't change anything.
Well, change the definition.
Well, not for us. we still work under the CSIS Act, so what we do is the definition is Section 2 of the CSIS Act.
Where information is shared, though, I should specify, where information is shared is now subject to SCISA, which is a broader definition. So my point being, if we talk about information sharing, would you have any concerns with information sharing being limited to threats to the security of Canada, the definition in the CSIS Act?
Let me take a stab at this. I think we have to be careful about would we have any concerns. The old maxim, silence deems consent. I think that's we have to be careful about that. But we've got to remember SCISA covers more than the service. It covers 17 departments and agencies, many of which don't have any definition at all. I think the rationale for the definition that's in place is, in fact, to provide guidance to other departments and agencies that are operating in a completely different context than the service.
So I guess I'm out of time.
I'm afraid you're out of time.
If you follow up in writing, if you do have specific concerns with the difference in definition, and if sharing of information was actually limited to threats to the security of Canada as defined in the CSIS Act.
Thank you. Monsieur Généreux, vous avez 5 minutes.
Mr. Généreux, you have 5 minutes. Thank you, Mr. Chairman. Thank you to the witnesses. Mr. Coulombe, the government has assured us that in the area of refugees and immigration, the investigations are carried out by your service. Is that the case? We do part of this work. We're responsible for the national security aspect. There are other aspects that come into play, and they're dealt with by the RCMP. Forgive me. I was writing something. I was asking Mr. Coulombe the following. The government says that with regard to immigration and refugees, the security investigations that are carried out by the department, and I was talking to Mr. Coulombe, you take care of one aspect and he takes care of the other, yes. Do you use social media? What are the technological means that you can use? What can you investigate without impacting upon people's privacy rights? Where's the balance?
Do a series of things. We will, on immigration files, we will do our holdings, our police holdings. But it's quite clear that if people are seeking to come to this country, it's very unlikely that they have much of a history in this country in terms of the traditional criminal indices checks. But we do our indices checks, and we check fingerprints, and we check other things, and we check open source material. And the intrusion on privacy isn't a huge consideration, given that we're doing these indices checks that we hold that are governed according to existing statutes.
Au niveau des,
What happened in St. Bernardino, California? The national security officers said on ABC that they were not allowed to consult social media to get information on people because of privacy concerns. Is that the case in Canada as well?
so you're allowed then. You can use the media, social media.
Yeah, we do, not to overstate it, but we do what we refer to as open source checks. So we'll check the internet for available information that will give us some indication, like we do for applicants to the RCMP, like we do for security clearances in support of the broader government efforts to understand who we're dealing with.
So c'est pas un enjeu de vie privée.
So it's not a privacy issue using social media or other platforms? Where's the line?
A clear line. I think people that use social media, like we don't do any sort of search and seizure. We aren't doing, we're looking at records that are in the public domain. And therefore, if we find that we have to go and do some searching, like a traditional search pursuant to how searches are generally understood, we would get a search warrant. Okay. But like Facebook and Google and those kinds of things.
Okay. Est-ce que l'arrivée de C-51...
And did C-51 change your work methods? Were there improvements flowing from it? Did it increase your toolkit? in order to be able to delve further in your investigations and searches on some individuals?
Have any impact?
No?
No.
Okay. Dans les...
In the context of our study that's underway, and we discussed this earlier, the minister even stated that with regard to technology, there are potential threats. In some cases, we perceive them, in others not. He talked about going dark, so you're completely under the radar. I don't know how one could determine that you're under the radar, if you are, but I imagine you have tools to determine this. Might you tell us a little bit about these potential threats that are technological, but that are used by hackers, other organizations that can use this in order to threaten us or people in Canada? Thank you for the question. I will start, and perhaps my colleague could speak to this as well.
We have, certainly from the police, and I know that I speak for my colleague, when we talk about how we're going forward to deal with these encryption and going dark and managing things in the internet. It is, as I say, the single greatest impediment to our effective investigations as we proceed with managing the terrorist threat.
I'm afraid I need to end there. Mr. Mendicino.
This is for attending today and for testimony. I want to draw your attention to what is now Section 12.1 of the CSIS Act, and it's a section that has attracted a lot of public dialogue and, to be fair, a lot of criticism, to put it bluntly. And the section essentially authorizes the service to undertake certain measures which could potentially infringe the Charter. I just want to verify that that provision has not been used to date.
That's correct.
Was the service consulted by the last administration of the need for this particular provision?
Yes.
Are you at liberty to say whether or not the service's position was that this provision was needed in order for you to fulfill your mandate?
There is a convention that advice to a previous government stays with the previous government, and most governments like it, particularly when they're no longer the government, so which happens from time to time. So I would encourage my colleague to restrain himself.
Abide by that convention?
Restrain himself.
Okay. The reason why I'm asking the question is that as part of this consultation, I anticipate that we will hear a number of witnesses who will say that that 12.1, the provision that would authorize service personnel from undertaking threat reduction activities which could infringe their charter rights, is not necessary for the purposes of CSIS fulfilling its mandate. And so in the spirit of anticipating those questions, I wonder whether or not you might comment about whether or not there might be improvements made to that particular section in a way that is respectful of the Charter.
Sans aller à l'encontre de la Convention.
Without going against this convention, without thwarting it,
About 24 times now, so I cannot sit here and say it's not useful. We've used them. What I can say, though, is the way that new mandate is articulated in our Act, that could be looked at, it could be changed, it could be left as it is. That's, again, a policy decision, and that's not for me to decide, and the service will work with the tools that it's provided with. But the tool itself, in the current threat environment, I believe is useful.
Can I put it to you another way? Prior to the introduction of what is now Section 12.1 of the CSIS Act, was there a prevailing view that CSIS was not able to fulfill its mandate?
Well, it depends what you talk about mandate. We were able to fulfill our previous mandate, which was to investigate and advise government. What we couldn't do was reduce the threat. So, like, the threat reduction doesn't have any impact on the mandate we had until C-51, which was to advise government. what was felt, and in fact, if you go back to 2010, CERC raised this issue. It was raised as a special Senate committee on terrorism, the whole issue of the service not being able to disrupt threat. It had no impact on our previous mandate to advise government, but it had an impact in terms of being able to reduce the threat in the current environment where it's fast-paced, much more volumes, technology, encryption, we've just talked about going dark. So it's an additional tools that we can use.
So I should be a little bit more specific. What I'm referring to are those threat reduction activities which could potentially infringe the Charter. So if you look at that into two subcategories, I'm really referring to the latter. Those activities which under 12.1 sub 3 could infringe the Charter. Do you have any views about that today that you're able to share?
Well, Michelle may want to add a bit. Minister and Michelle have both said it's never been used. I think the question is difficult for officials to respond to. There are scenarios where you could describe, that could be described, and the green paper.
I'm sorry, I'm going to have to interrupt because I want to get one last question in before I lose my time. Do you take anything from the absence of having to use those powers since the last time we asked? Is there a trend developing that perhaps maybe you don't need them as much as you did the last time you reported, or is it just happenstance?
No, the fact that we haven't used them doesn't mean that we couldn't use them.
Thank you very much.
Thank you.
Mr. Bressard.
And thank you all for being here today. Commissioner Paulson, I want to pick up on something you ended with Mr. Genereux and the single most important issue that you face with respect to managing threats, encryption, going dark. The Green Paper speaks to lawful access in the absence of a clear law governing access to basic subscriber information, name, address, IP, for example. It's made it difficult for law enforcement to obtain it in a timely and effective manner. Now, some other countries allow police and intelligence agencies to obtain basic subscriber information without going to court. In your opinion, should we be looking at amending the legislation to allow law enforcement and intelligence agencies to obtain basic subscriber information without a warrant? And I'd like to hear from all three of you, are there any other changes within the scope of this national security framework that we're looking at that law enforcement or cyber would like to see changed or amended?
Okay, well, maybe I'll start and say absolutely yes. I have advocated publicly and aggressively for basic subscriber information without warrant, to my peril in many instances, but I think it's vital. I think the encryption discussion has not yet fully taken place, and the understanding of the implications for privacy concerns is not well distributed. In other words, people don't have a fair understanding of what we're talking about. But to use my colleague from the FBI's analogy, it used to be that the corner of the room used to be dark, and we were all happy with that because we knew that, say, foreign governments or espionage networks were working in this very clandestine place where we couldn't see. But that darkness has crossed into the lion's share of the room now. And traditional criminality, like terrorism, like organized crime, like child exploitation, like fraud, is being advanced, supported, and accelerated by the availability of these commercial encryption programs. It's devastating to counterterrorism investigations, and it's a big challenge.
Mr. Colomb, do you have anything you'd like to add to that, please?
The only thing I'll add, when you look at the going dark issue, it's important to understand we've just talked about subscriber information, we've talked about encryption. The going dark problem is broader than that. It's intercept-capable network, it's data set sitting in a foreign country that we don't have access to, but that are used by Canadians. So it is important to understand that the going dark is a complex issue with multifaceted, and it needs to be understood. But I totally agree, huge impact, certainly our investigation. I mean, some of our targets basically the vast majority of their communication are encrypted.
So with respect then to information sharing between not just domestic agencies, but also foreign agencies as well, are there improvements that need to be made in that regard as well that we should be looking at from a legislative standpoint?
Well, we talked about, my colleague from Public Safety was talking to one of the government questions about MLATs and so on. It's very, it's a cumbersome process. It's very legalistic. It takes a lot of time, and we have to do better there, frankly, and I've raised that with my colleagues at Justice, but it is, by its nature, cumbersome, and so we need to think through never mind the assessments of the practices of the foreign country with respect to your other colleagues' questions, but just the legal process of getting the evidence into Canada so we can use it in court is very cumbersome.
Okay. How much time, Mr. Chair? So the Green Paper also speaks of threat reductions, but in it there's no distinction between home and abroad. How would you classify that distinction between home and abroad? Mr. Coulombe, obviously that question would go to you.
Well, there's no distinction because we can actually fulfill our mandate, both investigate, advise, and threat reduction here and abroad. So the same policy apply as far as internally. The same policy, it's all based on risk evaluation. So there is no distinction in terms of the risks might be higher if it's outside the country, but in terms of management of those operations, there's no distinction.
Okay, thank you.
Thank you very much. Mr. Diorio.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you once again for your attendance here today. I would like to talk a little about counter-radicalization. And before dealing with that, the radicalization phenomenon itself and the role of communities. We have this radicalization phenomenon, and we know that communities, well, they're struck. Families are involved when they have children who participate in these violent activities. Families fit within a community framework. So what role do you see for those communities in prevention, in detection, and in countering these radicalization activities? So you direct staff, but most clearly there is a role for these people who belong to these communities, who are involved or close to people who are involved. And perhaps they could voluntarily support you and law enforcement. That role is critical for several reasons. For the service, the fact that people are able to detect these signs, they'll report them to the service or to police services like the RCMP. And this is extremely important to have that network. But more important still, and the best example is what was put in place in Montreal, the role of the communities, the families, to prevent radicalization. Because the role of the service intervenes once the phenomenon is underway, once it's been triggered and these people present a threat. But before that, the role of these communities is extremely important, and I believe that here again, Montreal is a good example that should be looked at. What are you referring to? The center there. But that center is funded, it hires staff, it's active. These are jobs for those people. I'm not referring to that. I'm referring to people who belong to the community, who take charge of the situation and who voluntarily intervene and support forces like yours, like that of Mr. Paulson. But it's all of that together. And Monique could perhaps intervene as well. Yes, I fully agree with what Mr. Coulombe has just said. It's fundamental that we work with all of the interveners, all of the stakeholders, the communities themselves, and social interveners, social workers, law enforcement, provinces, territories, municipalities. It's a collective, joint effort throughout the country. I understand, but I want to deal with what I just brought up. In other words, not structured groups funded by the state, by the government, organizations like the center you've referred to, but individuals who are impacted upon, or their family or their community. My question is for Mr. Paulson. I think within his staff, there are people who have established relationships with these communities directly.
Endorse what the government's doing in respect of the coordination of counter-radicalization work at public safety. The police experience, as you'll know, has been outside of counterterrorism to engage with the very people that you're talking about, right? To have crime prevention strategies, to have outreach initiatives, to be able to inform the citizens of a given community about the risks of criminality and prevention. And we are using that through the CACP and other mechanisms in the RCMP to take advantage of those outreach connections into communities to inform citizens, to alert them, particularly those who are at risk, to what they can look for, what resources are available to them to bring to support their problems. And so I agree.
Thank you. Another question. Are there powers that you don't currently have and that you deem you would need?
Is that related to the former question?
Pandora's box.
No. I think the answer is yes. No, I'm kidding. Look, I think it's a very delicate area that has to be trod upon, particularly by the police, very carefully as we go into. I talked to the FBI recently about their counter-radicalization efforts. They're very circumspect and careful about wanting to take on the responsibility of counter-radicalization. I assert the police potential for using these pre-existing networks into communities because in Canada, crime prevention is how we do policing, community policing.
I think there's lots of evidence that demonstrates grassroots, community-based efforts on counter-radicalization the most effective. So one of the challenges is not to design a "we're from Ottawa, we're here to help" program across the country in terms of counter-radicalization, but to build on best practice, to share that. The vast majority of it is grassroots and led by family members who have gone through the experiences you've just described. So I think we're pushing on an open door here. The challenge is also to recognize that counter-radicalization has limits in terms of it's something you have to do, it does pay dividends, but it's not going to prevent and stop every single threat that we're going to otherwise confront.
Thank you, Mr. Brown. Je pense que pour la première fois, Monsieur.
I think that for the very first time, Mr. Dubé will have the final 3 minutes. Thank you very much. I'll take advantage of this to follow up, Mr. Paulson. I had a question concerning some stories that have come out over the last few years with regard to staff and staffing. Combating terrorism is a mission that has taken over, and it seems that the RCMP, because of this, doesn't have enough resources for crime prevention. Sometimes solutions can be easier than simply offering the necessary resources to the men and the women who ensure our safety and security.
We're looking at our resourcing levels. We continue to transfer people out of other areas into counterterrorism investigations. Our officers are underpaid in comparison to their contemporaries in city police forces. It's a very difficult HR environment to continue to maintain the pace and tempo of operations that we have. I agree.
Well, that's good to hear. And I'm just wondering, when the debate goes on about what could or could not be done in cases that are tragically behind us, I'm just wondering just the weight of legislation versus resources, because I believe, and as many others do, that sometimes the solution is not necessarily changing the law as was done under the previous government, but perhaps ensuring that police have the resources to be able to enforce already existing laws. Would you agree with that? And perhaps you can elaborate on what your experience has been.
Well, I would agree with that, but let me also say that my colleague at the service would agree with that. We are running hard in the counterterrorism business, my colleague and I, And you got to wonder at what point it's not just a temporary transfer of resources. I think I've said in the past, and I know Michelle has, it's not sustainable for the long term. We are meeting the threat, we are managing as best we can, but there's costs for that. But as to the balance between legislation and resources, I think that's for you to decide after you've had all the evidence.
Dans la dernière minute qui me reste, je vous poserai une dernière question.
In my final minute, I have a last question for you. Might you be able to tell us what elements are being abandoned in favor of the fight against terrorism? What is being sacrificed because of a lack of resources?
A little too strong a word. We've taken our investigative resources from areas of organized crime and financial integrity work. Our federal policing mandate, which is manifold, is predominantly focused on the counterterrorism threat.
Merci.
Thank you. Thank you very much. And thank you for, again, coming to our committee meeting. And no doubt we will see you again over the course of this year. The meeting is adjourned.